Good morning, everyone. I think we'll get underway just at top of the hour. My name is, first of all, thank you all for joining us today. My name is Scott Sweatman. I'm the moderator of the session this morning, or good afternoon. Some of you, I'm in Vancouver. I'm a partner in the Vancouver office. My practice focuses on pensions, benefits, and executive compensation related tax law. I'm pleased to be joined today by my colleagues and Adrian Miedema, who's a partner in our Toronto office in the employment area, Claire Brown, an associate of our Toronto office, and Janice Pereira, also an associate in our Toronto office. For some of you who attended these previously, and I believe this is our 31st session post-pandemic, I'll be glad when we can not refer to the pandemic quite so regularly, but let's hope that's in the near future. But the last discussion included was with our global colleagues, for those that were on the line, who shared tips and considerations for employers regarding the right to disconnect law. I'll talk more about that in a minute. So without further ado, I'd like to introduce the first speaker. Adrian, please take it from here.
Thanks very much, Scott, and good afternoon or good morning, everyone. So I'm going to be talking about employer vaccine mandates to give an update, given the reopening, so to speak, in large parts of Canada. How does that impact existing employer vaccine mandates? Can you still have them? Do you have to drop them? What are the considerations that you have to think about at this point? So that's what I'm going to be covering. But we could have the next slide, please. So as all of you will know, the provincial proof of vaccination requirements to access certain businesses and events and types of services like restaurants in various provinces, Alberta, Ontario, and Quebec in particular, have been lifted. BC still has theirs in place, likely for, it looks like, for a short period of time. But the federal vaccine mandate remains in effect at this time. The question is, if you're in a jurisdiction where the government has lifted their proof of vaccination requirements, does that change your ability to have an employer, your own company vaccine policy? And the short answer is no, it doesn't. Just because the government has ended proof of vaccination requirements for certain businesses doesn't mean that you as an employer can't continue to have your own vaccination policy tailored to your own workplace because of your own particular needs, because of the people that you serve, the circumstances in which your employees work, all of those sorts of things, which I'll talk about in a minute. So short answer is no, you don't have to drop your vaccine policies simply because some of the provinces have dropped their proof of vaccination requirements. Next slide. So as we've been saying all along with vaccination policies, two of the critical things that you need to think about, of course, are if you're going to have a vaccine policy for your employees, you have to accommodate medical and religious exemptions. And many of you, I know, with our help, also have been navigating some exemption requests or many exemption requests over the past few months. And also in provinces with provincial privacy statutes like Alberta, BC, and Quebec, you also have to be mindful of the requirements of local privacy, provincial privacy statutes. In the unionized context, of course, you've got an extra layer of review where arbitrators can review the policy not only for compliance with human rights legislation or privacy, but also for the reasonableness of the policy in the collective bargaining relationship. And interestingly, up to date, for those of you who have been following the cases that have come out so far, you'll know that the vast majority of arbitration cases that have come out have sided with the employer, where arbitrators have recognized that this is a COVID global pandemic that's killed millions of people is not the kind of thing that we can fit into our typical boxes. We need to take a fresh look at it. Employers are entitled to act on this. And vaccination policies are part of that. So from an employer perspective, very good to see that these cases have largely sided with employers. I wanted to just quickly read some quotes from two very recent vaccination arbitration decisions that have come out. One of them last week involving a Coca-Cola bottling plant, and one from this week, actually Tuesday, involving the Toronto District School Board. Both of them, again, sided with the employer. And it's interesting because the cases are now getting into, of course, well, what's the effect of the Omicron variant with respect to how the vaccines and how effective the vaccines are, the rapid tests against Omicron, how does that change, if at all, the approach that employers need to take? And interestingly, in the Coca-Cola case, the arbitrator noted that rapid antigen tests are less sensitive for the Omicron variant compared to the Delta variant in nasal samples, especially in the first 1 to 2 days after infection. A single negative rapid antigen test result cannot reliably rule out infection. A single negative test result is not conclusive and should not be used as a green light for abandoning or reducing precautions. So the arbitrators have actually said, with Omicron, the rapid tests are actually less effective, which in their view makes the vaccination requirement in some workplaces even more important. And the arbitrator in the bottling case said that the employer's interest in this case in maintaining the health and safety of the workplace and taking every precaution reasonable for the protection of a worker justifies the policy, notwithstanding the difficulty of the choice for some employees, the choice of deciding whether or not to get vaccinated. So the arbitrators are focusing on the science with respect to the rapid tests and vaccines, but also very clearly on employers' ongoing obligations under the Occupational Health and Safety Act to have a safe workplace. That's been a consistent theme. And then the arbitrator, just in concluding in the bottling case, says, I have found the policy and the placing of non-compliant employees on leave without pay to be reasonable and not contrary to the collective agreement. I note that notice has been one of the hallmarks of the company's implementation of this policy. Consistent with this approach, I believe it is appropriate that non-compliant employees be provided with an opportunity to commence the vaccination process before facing the potential for discipline. So in this case, the company put employees on a leave of absence, gave them lots of notice about the requirement to get vaccinated, and that if they didn't get vaccinated, there would be employment consequences for them. So again, in the bottling case, the arbitrator upheld the vaccination policy. And then in the Toronto District School Board case, which just came out on Tuesday, involving arbitrator Kaplan, who's a very well-regarded labor arbitrator. It's a much lengthier decision, probably not surprising given that it involves the school board. And again, there was a discussion about the rapid tests, and the arbitrator said that he did not accept one of the expert witnesses' views that rapid tests can be an appropriate substitute for full vaccination. The arbitrator said, no, vaccination is a better approach than rapid tests. Rapid tests are not a substitute. And he said, frankly, it is not immediately apparent to me in a process informed by the precautionary principle why the TDSB, Toronto District School Board, would accept rapid tests as an alternative to vaccination, especially in congested workplaces like schools, where the expert evidence is clear. We're hearing this term come up, the precautionary principle, which effectively means when you're faced with such an unprecedented global emergency event, public health matter, employers are entitled to approach matters with the precautionary principle, that is, to take precautions that they think are best in the circumstances, and to take sort of a conservative approach to these things because they involve people's health. And then the arbitrator went on to say, it is my finding, agreed to by the experts, that vaccination is the best way of preventing transmission at schools. It is also my finding that whatever the value of rapid tests, they do not provide the same level of protection to staff and students, and should only be relied on in cases of absolute necessity, such as to facilitate essential and otherwise justified exceptions. And went on to say, very interestingly, in looking at the change from the pre-vaccine to the post-vaccine time period, once the vaccines arrived and were determined to be safe and effective, the paradigm shifted. The rules were appropriately revised when the scientific situation changed, namely the unequivocal evidence that full vaccination provided the best available protection against contraction and submission. The policy gave effect to this conclusion. With this new evidence, past practices were revisited. It would have actually been derelict to ignore the vaccines and the benefit of full vaccination and pretend that they were not a real game changer in giving effect to the school board's statutory obligations. Again, the precautionary principle requires that employers like the Toronto District School Board, subject to their constitutional obligations, do whatever they reasonably can, and that is what they did in this policy. So again, very strong language about employers' obligations to take all precautions that they can for the safety of their employees. Even in light of the Omicron variant, the arbitrators have been upholding the vaccination policies to date for the vast majority of decisions. Now, interestingly, in the TDSB case, the board had actually repealed its vaccine mandate by the time that the decision came out, but the arbitrator found that it was still reasonable for the period that the vaccine mandate was in effect. So just a reference to a couple of very recent cases to show you that employers continue to get support from decision makers, and in particular labor arbitrators, on vaccine policies. Next slide, please. So when you're thinking through, okay, we've got a vaccine mandate right now, vaccine policy for our employees, should we repeal it or lift it? And if so, when? And here we've listed some factors for you to think about when you're making that decision. The first is the Occupational Health and Safety Act and your duty to provide a safe workplace. And again, we heard the arbitrators refer to the precautionary principle. You're entitled, it appears, to take a conservative approach oriented towards the safety of your employees and the functioning of your workplace. So safety, obviously a top priority. The efficacy of vaccines in preventing transmission and infection. And I think the data, even on Omicron, continues to show that vaccines do have value in preventing transmission and infection. Current public health guidance, we'll all need to stay on top of that, because there may come a time when public health officials say vaccine policies should not be used anymore, or need not be used anymore. And then if and when that time comes, then employers will need to take that into account. Do your employees work in teams or at home? Obviously, the more your employees work together in a workplace, the more likely you'll be able to uphold a vaccination policy. Doesn't mean that you can't succeed if people are working remotely, but certainly if people are working together, particularly with other people who may be vulnerable, that's an important factor. Also, just factors like risk of employee absences. If you don't have a vaccination policy and you have a number of unvaccinated employees, are you going to be dealing with employees away from work for extended periods because of isolation? How's that going to affect staffing levels? Look at what your sector or industry is doing. That's also very important. Think about the ending of provincial COVID leave. So for instance, in Ontario, what we call the deemed idle or the deemed infectious disease emergency leave. This is the sort of layoff converted to a leave provision that the government put in for COVID, is ending on July the 30th, 2022, which means you won't be able to put employees on this COVID leave anymore if they're off work because of the vaccine mandate. So you have to keep that in mind. How does that affect your legal risk and strategy? Ending of the provincial COVID leaves, as I've already talked about that. And also, where the rubber hits the road, if you have a vaccine policy, what are the consequences of non-compliance with it? Are you going to terminate people for cause, without cause? Are you going to put them on a leave? You're going to have to think all of these things through with the shifting public health guidance and the shifting data. Practically speaking, we've so far seen very few employers just completely drop their vaccine mandates. It seems that most so far are taking a cautious approach and continuing to have their vaccine mandates in place. I think a lot of companies are revisiting it and regularly reviewing them. But so far, as you've probably seen, very few companies have publicly announced that they're dropping their vaccine mandates. So in summary, what we're saying to our clients is, if you want to continue with your vaccination mandate, you probably can, and just go ahead and do it. Obviously, considering these factors and updating the public health guidance, keeping up to date on public health guidance. If you want to drop your vaccine mandate for whatever reason, you can also do that. There are various things to keep in mind when you do that, especially if you've got outstanding litigation with respect to any other employees that have been affected by the vaccine mandates. So that's it for me, and I'll turn it over to my colleague, Claire Brown.
Thanks very much, Adrian. And good afternoon, everyone, to those of you joining us from the East, as well as good morning to those of you joining us from the West. As we continue to navigate the impact of the pandemic on business operations, the provincial governments have taken a series of steps to lift some or all of the COVID-19 related restrictions that were implemented to address the COVID-19 pandemic. In light of the flurry of activity that has taken place on this front over the past few weeks, we thought that it would be helpful to provide you with a brief overview of where the restrictions currently stand in each province across Canada. Next slide, please. Thank you. As I mentioned, certain provinces have lifted all COVID-19 related public health measures, which were generally implemented through a number of public health orders to control the impact of COVID-19 on the population. In particular, the provinces of Saskatchewan, Manitoba, New Brunswick, and Newfoundland and Labrador have lifted all public health orders related to COVID-19 restrictions. As such, these provinces have lifted their mandatory masking or face covering requirements, capacity restrictions, physical distancing requirements, and proof of vaccination or vaccination passport requirements. However, many of these provinces note that although the provinces have lifted the mandatory COVID-19 related restrictions that were previously in place, businesses, workplaces, and organizations may choose to leave certain restrictions, such as masking requirements or vaccination mandates, in place. In Alberta, the province lifted the remaining capacity restrictions that were in effect, including with respect to indoor and outdoor social gatherings, the mandatory work from home requirement, and the province's provincial mask mandate, subject to certain exceptions, however, including on municipal and interprovincial public transit, as well as AHS operated and contracted facilities and all continuing care facilities. While in Nova Scotia, the province has lifted all gathering and capacity limits, physical distancing requirements, and masking requirements. Further, businesses and organizations are generally permitted to resume full operations with no mandatory public health restrictions, while special events such as festivals, sports, performance meetings, training, and faith services are also permitted to resume operations in full. However, certain restrictions remain in place for high-risk settings, such as healthcare and long-term care. Next slide, please. Thank you. In British Columbia, the province has lifted its public health order setting out face covering requirements. Further, the province has listed the capacity limits applicable to indoor and outdoor personal and organized gatherings. The province has also lifted the requirement that employers allow workers to work from home, their private residence, if possible, given the nature of the work involved, unless the employer has an operational requirement to have the worker work at the workplace. Proof of vaccination requirements, however, remain in place for accessing certain businesses, services, and events, as well as the requirement to implement a COVID-19 safety plan that sets out a number of measures and requirements as identified in the order of the provincial health officer. However, it is expected that these two requirements will also be lifted on April 8th, 2022. Next slide, please. Thanks. In Ontario, the province has lifted capacity limits on social gatherings and indoor public settings, the requirement to implement a COVID-19 safety plan, and proof of vaccination requirements with respect to accessing certain businesses, events, and services. In addition, the province lifted most of the mandatory masking requirements in place, subject to certain exceptions, including with respect to businesses, organizations, and municipalities that operate indoor premises and vehicles used in the operation of public transit services, as well as the healthcare, retirement, and long-term care sectors. However, we note that the person responsible for a business or organization that is open remains required to operate the business or organization in compliance with any advice, recommendations, and instructions issued by the Office of the Chief Medical Officer of Health, including any advice, recommendations, and instructions on physical distancing, cleaning, or disinfecting, requiring the business or organization to establish, implement, and ensure a compliance with a COVID-19 vaccination policy, and setting out the precautions and procedures that the business or organization must include in its COVID-19 vaccination policy, where published by the province. Next slide, please. Thank you. In Quebec, the province has lifted most of the public health measures associated with the COVID-19 pandemic, including gathering restrictions and the vaccination passport requirements. However, the province's mandatory masking requirements remain in effect. In particular, a quality mask is required to be provided by the employer and worn by staff in indoor and outdoor workplaces when physical distancing of 1 meter cannot be maintained, or in the absence of an effective physical barrier. We note, however, that we expect the province's mandatory masking requirements may be revised over the next month. Next slide, please. Thanks. Lastly, in Prince Edward Island, personal gatherings are limited to a maximum of 20 people indoors and 50 people outdoors, while organized gatherings are limited to up to a maximum of 75% capacity, with space being maximized to allow for as much physical distancing as possible. In addition, fitness facilities, retail operations, casinos, and libraries are required to limit capacity to up to a maximum of 75% of occupancy, while operators of businesses, services, and organizations that offer food and beverage services are required to limit the occupancy of the operating capacity of the facility to 75%. They are also required to take every reasonable step to maximize the use of the facility's space to ensure that persons from different households maintain a distance of 2 meters from each other, limit table capacity to a maximum of 20 persons per table, and ensure that food and beverage is served and consumed by patrons while the patrons are seated. The province's mandatory masking requirements remain in effect as well. And in addition, the operators of businesses, services, and organizations that are open to the public are required to take the following preventative measures: to take every reasonable step necessary to prevent employees who are required to self-isolate from entering workplaces, to develop and follow an exclusion policy that ensures that symptomatic employees are immediately excluded from work activities, to develop and follow an operational plan detailing how the risk of transmission of COVID-19 will be mitigated, to ensure enhanced cleaning and disinfection of shared areas and surfaces takes place, to ensure that hand washing stations are available, to follow any direction issued to a specific class of businesses, services, or organizations, which may include COVID-19 public health measures guidance, as may be amended from time to time, and to follow any other direction issued to the business, service, or organization by the Chief Public Health Officer. And with that, I'll now turn the floor over to my colleague Janice, who will discuss what you need to know about changes to Ontario's employment laws. Over to you, Janice.
Thank you, Clara, and a happy Friday to all. Thanks so much for joining us today. So on February 28th, the Ontario government introduced Bill 88, which is the Working for Workers Act 2022, not to be confused with the Working for Workers Act 2021. Now, if passed, this omnibus legislation would accomplish several things. Next slide, please. And we're going to touch on some of the more important things this afternoon, which in a nutshell include amendments to Ontario's Employment Standards Act, in particular, the introduction of a requirement for employers to disclose to their employees if and how they electronically monitor their employees. The Working for Workers Act 2022 would also amend the Occupational Health and Safety Act, or OSHA for short, to increase maximum fines for OSHA violations. Finally, the Act, if passed, would also enact the Digital Platform Workers' Rights Act 2022, which establishes minimum entitlements and protections for digital platform workers. So let's now take a look at each of these items in a bit more detail. Next slide, please. So the new amendment to Ontario's employment standards legislation will require employers with 25 or more employees in Ontario by January 1st of each year to have an electronic monitoring policy in place by March 1st of that same year. For 2022, however, such policies would need to be in place within 6 months after the day on which the Working for Workers Act 2022 receives royal assent, and that date is still to be determined. Now, the Act doesn't really define what electronic monitoring means and what this would entail, but this would likely include the tracking of employees' locations through devices such as GPS. This would also include technologies used on corporate networks and devices such as laptops, computers, or even cell phones that are provided by employers to their employees. The government's announcements today don't really indicate whether general IT records, such as logs created when an employee signs into their work account or email account, would constitute electronic monitoring. But we do anticipate that these details will be addressed once regulations under the Employment Standards Act are finally put into effect. So now on the next slide, we can take a look at what such electronic monitoring policies need to include. So they'll need to include information regarding whether the employer electronically monitors its employees. And if it does do so, there needs to be a description of how such monitoring is performed and under what circumstances. Finally, the policy also needs to include the employer's purpose for collecting information through such electronic monitoring. So for example, employers might have policies in place that prevent employees who are working remotely from doing so outside of the country, as this could potentially have tax implications for an employer. So if the employer tracks the location of an employee's remote working connection, for example, then the employer would need to disclose this in their policy, along with the fact that this information is being tracked in order to ensure that the employees do not work from outside of the country. Now, this is just a small example of what such an electronic monitoring policy and its contents might look like. But of course, such policies would need to be tailored to reflect the realities and nuances of each employer's business and workplace and business needs just generally. Employers will be required to provide copies of their electronic monitoring policies to each employee within 30 days of introducing the policy or any amendment to the policy. Policies also need to be dated with any amendment dates tracked as well, which is very important for employers to keep in mind because it will be a part of the legislation. So on the next slide, in addition to the proposed ESA amendments, the Working for Workers Act 2022 also introduces amendments to Ontario's Occupational Health and Safety Act. This includes a dramatic increase to the maximum fines that are applicable in the event of an OSA violation. So for example, while directors and officers of a corporation can currently be fined in an amount up to $100,000, this amount will increase to a whopping $1.5 million. And for all other individuals, while the current maximum fine is $100,000, this would go up to $500,000. A list of aggravating factors would also be added to the OSA that would be considered when a decision maker is determining the amount of a penalty in response to an OSA violation. So for example, this includes offenses resulting in death, serious injury, or illness to one or more workers, if the defendant committed the offense recklessly or acted in disregard of an order of an inspector. Another aggravating factor is if the defendant was previously convicted of an offense under the OSA or another act, or has a record of prior non-compliance. If the defendant shows a lack of remorse, if there's an element of moral blameworthiness to the defendant's conduct, these sorts of things would also be considered to be aggravating factors. If the defendant was motivated by a desire to increase revenue or decrease costs when commissioning the offense, or tried to conceal the offense after the fact, these would be considered aggravating factors as well, which would likely militate towards a larger fine amount. Finally, the limitation period for instituting a prosecution under the OSA will be extended from 1 year to 2 years, which is quite a drastic change. So on the next slide, we will discuss one more amendment to the OSA, which is the requirement for employers in certain situations to provide and maintain Naxalone kits in their workplaces. This requirement applies where an employer becomes aware, or ought to be reasonably aware, that there may be a risk of having an opioid overdose at its workplace, or where certain prescribed circumstances exist. So this amendment to the OSA is likely a response to the opioid crisis in Ontario. And just to offer an idea of how serious the opioid crisis has become, as of June 2021, according to Public Health Ontario, there were 17 opioid-related deaths per 100,000 deaths. and 120 emergency department visits related to opioid overdose per 100,000 visits. Employers who are required to have naloxone kits will also be required to provide training to employees so that they can identify an opioid overdose and administer naloxone as needed. Finally, on the next slide, we can take a look at the Digital Platform Workers' Rights Act 2022, which the Working for Workers Act also proposes to enact. Now, this act is a benefits conferring legislation, and it's geared towards providing entitlements and protections to digital platform workers. And the introduction of this legislation certainly isn't surprising in an era of rising gig work and the growing gig economy. Digital platform work is defined as the provision of work for payment, rideshare, delivery, courier, or other prescribed services by workers who are offered work assignments by an operator through the use of a digital platform. The term operator is also broadly defined to include a person that facilitates, through the use of a digital platform, the performance of digital platform work by workers. Now, this act would apply to any worker who performs digital platform work, irrespective of whether or not they're otherwise considered to be employees at law. So independent contractors, for example, who are doing digital platform work would be afforded rights and protections under this act that they wouldn't otherwise necessarily have available to them under the Employment Standards Act. Now, on the next slide, we can take a look at some of the entitlements under the Digital Platform Workers Act, which includes the same minimum wage rate payable under the ESA, which I understand is currently $15 per hour, not including tips and gratuities. This minimum wage requirement only applies during the active performance of services. So, for example, if a food delivery driver picks up and delivers a meal between 1 p.m. and 1:15 p.m. and then doesn't receive another assignment until 2 p.m., he or she would not be paid for their 45 minutes of downtime while waiting for another delivery assignment. Other minimum requirements introduced by the Act are a recurring pay period and payday for digital platform workers. Such workers would also have information-based rights, and this would include how their pay is calculated, how an app's algorithm works, and any particulars of a performance rating system that may be applied to such workers. Next slide, please. So to end off, we did want to note that a lot of these new provisions being introduced by the Working for Workers Act 2022 will certainly impact employers' privacy and cybersecurity policies. So if you do require more information to this end, please do reach out to my colleague, Kristen Thompson, who is our National Practice Group Lead for Privacy and Cybersecurity. Thank you very much for listening. And with that, I will pass it over to Scott to field any questions that our audience may have. Thank you.
Thank you, Janice. We've got several questions that have come up, and I think we can probably deal with the ones on the Q&A first. I've got a couple of questions for our speakers, but let's deal with some of the ones that are on the Q&A. The first one, and I'm not sure who wants to address it, I'll leave it to the panelists. Are you seeing any vaccination policies being amended to require a minimum of 3 doses? So instead of the 2, do you need to get the booster, for that matter, booster 3 or 4 as time marches on? Adrian, do you want to take that, or Claire, or either one of you?
Yeah, I'm happy to, Scott, thanks. The answer is yes, we are seeing some of our clients amend their policies to require 3 doses. That is consistent with the, I think, as we all know, the public health guidance. I think the challenge is a very practical one, and that is that, as we all know, the percentage of the population that has 2 doses very high. The percentage that has 3 doses is actually significantly lower. So employers that impose the requirement of the 3rd dose may have a practical issue on their hands where they have quite a percentage, and maybe frankly even half of their workforce that doesn't have a 3rd dose, but that has 2. So that can pose practical difficulties. But yes, indeed, many of our clients are making that amendment.
Perhaps a tangential question to that for you, Adrian, as well. Not on the list, but question being, if our company has put a number of people on leave because they did not get vaccinated, if we then drop the vaccination mandate, what should we do with those individuals that we put on leave?
Yeah, I think that if the folks were put on leave, i.e. they weren't terminated, and you've dropped the vaccination mandate or requirement, then it seems to me that the company is going to need to find to return those people, to reinstate them in their jobs, because they still have employment status. So the company's going to really need to make an effort to try to find a spot for those employees to come back to work.
Okay, thank you for that. Another question on the FAQ. In Ontario, can you have customers in the facility? So you want people to come back, customers to come back. If so, what needs to be done to allow that for those that have not had customers coming in until the mandates have been lifted? Either one of the panelists who'd like to jump in.
Happy to jump in on that one. So in accordance with the current restrictions that are set out in Ontario Regulation 364/20, which is the regulation that applies with respect to the roadmap exit step that we are currently in the province, there wouldn't be anything prohibiting customers from coming back on site. However, from a business practicality standpoint, I would suggest that the business may want to consider what measures are currently in place with respect to patrons or individuals on site, and whether those restrictions will also apply to customers, and from a strategic standpoint, understand how they would want to start bringing customers back on site. There also may be some apprehension with respect to customers coming back on site, so there may be some managing of expectations in terms of what that looks like as businesses make those steps and start having more folks back on site.
Thank you for that. Another question on the list, just so we can get to the list for a change. We usually don't have time for this, but we do today. The third question is a related question, really. Ontario has removed the mask requirement, as we just learned. But if the Halton region, as an example, still has mandated it, which of them are the employer obligated to comply with?
So I'm happy to take that one as well. So this one's interesting in that there's been a bit of change in terms of how the Ontario government is addressing measures that are implemented on a local basis by the local public health units versus provincially. And so prior to the latest moving to the roadmap exit step, the way the provisions were worded was that the businesses and organizations were required to comply with any advice, recommendations, or instructions issued by the local public health units. However, now the province has actually revised that language. So the revised language, and I'll read from the Act, now says, the person responsible for a business or organization that is open shall operate the business or organization in compliance with any advice, recommendations, and instructions issued by the local public health official under the Act before February 25th, 2022, other than the restrictions that are mentioned in the Act. So what that means is that with respect to this example, if the Halton bylaw that's being referenced with respect to being implemented, for example, was implemented prior to that date, the employer would be required to comply with it. However, if it's implemented after that date, the employer arguably would be required in the same way it was prior to this change to the legislation.
Okay, thank you for that. I have a question for Janice. Do you think, Janice, that the new requirements for electronic monitoring policies, if you're monitoring, you've got a policy, do you think it will limit or restrict an employer's ability to monitor its employees?
So that's a great question. The amendments to the ESA, at least in my view, mainly appear to be geared towards employers being more transparent with their employees about their practices, especially in light of the large number of employees who are now working remotely or on a hybrid model. So the short answer to this question is no. The proposed legislation does clarify that the requirement to have an electronic monitoring policy in place does not affect or limit an employer's ability to use information that is obtained through the electronic monitoring process.
Okay, thank you for that. A question that came through on the chat line, and any methods fine if you've got other questions, but by reinstating those employees not vaccinated, so come on back, we've relaxed our rules, or we're allowed to, if it opens the workplace to a greater risk of contagion, what do you suggest we do to mitigate that contagion and that risk that is potential? Either one of you.
Yeah, I can handle that, Scott. I mean, I guess the basic first question is, are you going to drop your vaccination mandate. And in considering whether you're going to drop it, you're going to consider, does this pose a risk that you're not prepared to take of employees coming back and infecting others? And if your conclusion is yes, it would, then you probably wouldn't drop your vaccination mandate. If you do drop it, presumably the employer will by that point have decided the risk is manageable, and then you're going to take the normal steps to manage it, considering mask wearing, which you can still do if you want to. You might still do screening, even though in Ontario it's not required anymore, specifically required. You might still do the daily screening. You could still have those steps in place. You could do testing, rapid testing of employees. So all of that is going to have to be part of the package that you're going to consider when making the decision to drop your vaccine policy, if you decide to do that.
Okay, that's helpful. Thank you. Claire, I've probably asked you this partly already, but I just want to get a better understanding of this. As the provinces continue to lift the mandatory COVID restrictions that were in effect, and it does vary as you've covered off across the provinces, and it seems to be a daily change, so you got to keep up with this stuff. What does it mean for businesses, particularly I'm thinking of businesses with multi-jurisdictional locations? Should businesses also be lifting the same restrictions in their workplace? You've got lifts, and should we immediately respond? I know I know what your answer is going to be, but I'm curious what you would have to say for particularly businesses across the country that like to have common policies to the extent they're able to do so.
Sure, happy to speak to that question. So I think what the first piece I would note that seems to be helpful is that although, as I mentioned, a lot of the provinces have lifted either some or all of their COVID-19 related restrictions that were in place, there tends to be also guidance from the province either continuing to recommend or strongly recommend those measures. So for example, with masking, the province will typically issue some sort of announcement that says masking restrictions will be lifted effective this date. However, the province continues to encourage or strongly encourage the use of masks. So it shows that although the mandatory requirement is lifted, there's still a strong encouragement of those measures. And so oftentimes the province's guidance will also say something to the effect of businesses, organizations, workplaces may continue to leave requirements that they've implemented to protect against COVID-19 in place. So I think it's setting the tone that although at a provincial level, it may no longer be a legal requirement. However, there's an understanding that from a business standpoint, those measures may still be in place. And the last piece I would note is that from an occupational health and safety standpoint, and looking at the duty to provide workers with a safe workplace and to maintain a safe workplace, from a business standpoint, it may be determined that those measures need to stay in place to ensure that a safe workplace is provided. So those would be the considerations that I would suggest are important in that context.
Thank you very much for that. I've got one for Adrian or any of you, but Adrian, perhaps you can address this one. If you want to drop your vaccine mandate, and you do so because you want people back to work to the extent that they'll come, and we do that, and there's suddenly an outbreak in the workplace, can you comment on the company's potential liability on that? I know it's probably a multifaceted answer, but high-level comment on liability for dropping and we have an outbreak. But for the dropping, we wouldn't have the outbreak.
Thanks, Scott. So I guess I'd look at it a couple of ways. One is under your provincial occupational health and safety legislation. It's not so much liability as enforcement. You could have your provincial safety inspector come in and start questioning your COVID practices and potentially issue compliance orders and possibly charges, or depending on which province you're in, administrative penalty, like in BC with WorkSafe BC and other provinces. So that would be one issue. With respect to potential liability, it's important to remember that if the employees work in a workplace that is covered by workers' compensation legislation, then in general, the rule is that the employees can't sue the employer for any injury in the course of their employment, which would generally include, and certainly in Ontario, getting infected with COVID in the workplace. So if there's an outbreak in the workplace, somebody gets infected, they would likely have to go to the workers' compensation board in your province. They would not be able to bring a lawsuit. You could potentially have this thing spread much further, where people take it home and their family members get sick and those family members sue. I think that the difficulty with any of those lawsuits would be, COVID is everywhere, and can the employer really do anything practically to avoid having it spread around? We all have friends and family that have gotten it, despite everybody's best efforts. So on the face of it, it would seem to me, unless the employer was really grossly negligent, it would probably be difficult to sustain a lawsuit against an employer for COVID spreading beyond the bounds of its employees.
That makes sense to me. Another question that's come in on the chat line regarding property management companies. So pick your management company. Can they still require a copy of a vaccination proof from their residents who want to use the gym or the pool or whatever within the building? Property management companies being concerned for all the reasons you can imagine. Could they still require that? Is that something that a property management company can or should do? Claire or Janice?
Sure, happy to take that one. So it's one I think that I would like to take back and confirm, but my hunch is that the answer would be yes, but I'd like to just double check and make sure there aren't any other regulations that I'm not aware of that may change the response to that inquiry.
Okay. Got another couple of questions that are coming in, so thank you for your questions, everyone. It makes my job a lot easier because I don't have to dream up the questions, but in Ontario, do people still need to sign into a site and answer screening questions prior to entering the building? We certainly lived that in our own firm. I'm not sure who wants to take that. This is an Ontario-specific question.
Sorry, that was with respect to
Ontario. So do I need to sign into an on-site, recall we had sort of on-site, I want to come to the office, I've got to fill out a form at the desk or online before I come in. Is that still a requirement, or could be?
Right. So that requirement was once in the piece of legislation I referenced before, Ontario Regulation 364/20, and it's no longer in the regulation. So no, it's no longer a legal requirement by the regulation. However, as Adrian mentioned before, when businesses are considering how they're going to operate their workplace and keep workers safe, et cetera, and folks safe in the workplace, there may be an interest in keeping those types of requirements in place to help monitor in terms of COVID and transmission, et cetera, in the workplace or among folks who will be attending the workplace, but the legal requirement is no longer in the Act at this time.
Okay, thank you for that. Here's a tough question. And the question is whether you could speak to the employer's liability in regard to adverse effects of the vaccine that the employer made mandatory. To comply with provincial law, presumably. Anybody want to comment or has looked at that? I got sick from the mandate or from the vaccine, but for your mandate, I wouldn't have had this adverse effect.
I'll handle that, Scott. I think the key is that you got sick from the vaccine and not from the employer, not from the employer's policy. Yes, it was the employer's policy that maybe encouraged you to do it, but I think the employer can easily fall back on public health guidance. The guidance has been very strong and consistent, as we all know. The vaccines are safe, they work, and we're strongly encouraged to get them. I think for an employee to say, I wouldn't have been vaccinated except for my employer's policy required me to be vaccinated, or I'd lose my job, therefore I got the vaccine, therefore I got sick, and therefore my employer's liable. Seems like a bit of a stretch to me to sort of tag the employer with that liability. So that's something that I think would have limited chance of success, in my view.
Yeah, thank you for that. I'm going to move a little bit west. A question from Alberta. If the vaccine policy was lifted in a workplace and then there's a change in the situation, another wave, and of course that's could transpire, let's hope not. Is it possible to reinstate the policy even if the province doesn't change their mandate? So we're going to bring it in, the province hasn't acted, we want to act. Janice or Claire or Adrian?
I think the answer to that is yes, unless there's a law that says you can't have a vaccine mandate, employer vaccine mandate. there's nothing stopping employers from reinstating them if the situation changes. And in fact, that's exactly what employers should be doing, is monitoring the public health guidance, monitoring the state of the pandemic, the variants, the effectiveness of vaccines. And if the employer believes, yeah, we need to reinstate, then you reinstate. Again, as long as the province hasn't passed a law that says you can't do that anymore.
Right. Yeah. And we haven't seen that. We have in the United States, of course.
Yes.
Some of the US states said, thou shalt not mask or mandate anything, but we haven't seen that in Canada, I don't think, anywhere, have we? I don't think so.
I think that's right, Scott.
We're running out of time. There was one question that and again, I don't think we have an answer, but will there be an electronic monitoring policy template available similar to the disconnect policy, which I'm going to plug one more time before we're done here today? Are we looking at an electronic monitoring policy template? I'm sure we're advising on it. In fact, I know we are, or will be. Claire or Janice?
Yeah, so once Working for Workers Act 2022 does receive royal assent, we expect to see more regulations being fleshed out under the Ontario Employment Standards Act. That would include what needs to be included in an electronic monitoring policy. So from that point forward, I do predict that dentists will be developing a template that we can then circulate to our clients. So yes, definitely stay tuned for that. Thank
you for that. I think I'm in interest of time. We promised you to be done by 9. We're almost, or by the top of the hour, depending on where you are. I think we'll wrap it up, given it's a Friday and everybody's got a busy day, I'm sure, or what's left of it for those in Ontario. Again, thank you so much to the speakers and the attendees. This has been as I say, I think it's our 31st or 32nd seminar. I remember when COVID hit, we had them weekly, as I recall. I've moderated a few. And they've been very well attended. I think we had over 600 subscribers, and a lot of you are still on the line. So we thank you for your interest in this. We hope and we assume you're finding these valuable. So thank you for that. Again, reminding you on this Ontario Disconnecting from Work policy is available, and you get that information. You can request a template from any of the team here or online. Justine Muller has put the link in the chat, so it's all there. As was mentioned, there's privacy assistance for the new Ontario laws. There are some overlap, and you can certainly reach out to Kirsten Thompson of our National Practice Group, lead for privacy and cyber security. That's available. The next webinar is, where are we? April the 29th. That's the Friday. We like doing these on Fridays. We hope those dates work for you. April the 29th. Look out for an invitation in the coming weeks to that. And in closing, I wish you all a happy and safe and spring-like, for some of you, weekend. And we will see you all, I hope, on April 29th. Thanks so much for participating.